Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today on this channel, we're going to be talking about mortgage bonds. This is part 4 in our series dealing with land. I had intended to only make this into 4 parts, but due to demand, I will make it into 5 parts where I will include a discussion on transfer duty and capital transfer tax in relation to land issues. Before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. A mortgage bond is a form of security made by one person in favor of another, where this person uses their immovable property to secure the repayment of a debt or a loan. And this mortgage bond is passed over immovable property. And by immovable property here, I mean any type of land that you might have. And this includes where land is held by way of a lease. Now, this is security for a loan to say if this loan is not paid back in time and in the terms that have been agreed by the party, then the property, after getting a court order, can be attached and sold in order to repay this debt. When a person passes this mortgage bond, then that person is said to be a mortgagor. And the mortgagor would be the one that owns the immovable property. The person whose favor this bond is registered is called a mortgagee. And this is the person who would be giving out the loan or the money. And here I'd like to clarify that when I say passed over a lease, I'm not talking about a lease in respect of someone living in someone else's house and paying them every month. I'm talking about long-term leases similar to those that are passed by the land boards, as discussed in my previous videos, and similar to those leases that are registered in respect of freehold land. And these have to be long-term leases as discussed in those videos. A mortgage bond can be used as security for an existing debt, a future debt, or both. And this is the reason why when you look at most mortgage bonds, you will see that they are called continuing covering mortgage bond. And this is in order for it to cover both this existing or future debt or both. Now in this video, we're going to be talking about a mortgage bond where, firstly, an owner of a property approaches a person and says, you can use my immovable property as security in order to give me the money. And we're going to be talking about a second type of mortgage bond called a surety mortgage bond. Now, in this first scenario, this is a very straightforward situation. The reason why it is straightforward is because you have the owner of the property approaching a bank, for example, and saying, I have this property, it is valued at 50,000 pula. Please give me 50,000 pula as the bank, and you can then use my immovable property as security to make sure that I pay this money back. In the second scenario, being the surety mortgage bond, it is different. The reason why it is different is because instead of just 2 people, now you have 3. These 3 people would be the bank, as an example, the owner of the property, and another party. And the way that surety mortgage bonds come into play is where this other party goes to the bank and says, give me money. And the bank says, in order for me to give you money, what is it that you are going to show me if you cannot pay the money back and I need to recover? This person then says, I know Mortgagor. Mortgagor has this piece of property and she is willing to let me use it as security. So inside this surety mortgage bond, you will have the name of Mortgagor being the mortgagor, the person who passes the bond. You will have the name of this person who is given the loan by the bank. And then you will also have the name of the bank. So inside this document, it will be shown that the loan is given to this third party and Mortgagor's property is being used as security for the loan to the bank. This means that if this person is not able to pay back that money, then if the bank wants to get its money back, it will sue both these people. It will sue Mortgagor because she used her property as security, and it will sue this other person because this person is the one that got the money. And if you watch my video on executions, if this property has been sold in execution for recovery of the debt and it hasn't cleared everything, it doesn't then mean that Mortgagor then steps back. No, Mortgagor is also supposed to pay everything that is left over if the property does not clear the debt. The bank will have the option to say, I have sued these two people, I have gotten judgment, I have sold the property. Let's say the loan was 100,000 and the property is sold for 30,000. The 70,000 that remains, the bank will decide whether to go after this person who was given the loan alone or whether they can go after Mortgagor or both using that judgment that they got. Meaning that the debt collection process, as discussed in my other video where I deal with debt collection, then can take place in respect of the person who got the loan, in respect of Mortgagor, or in respect of both of them. So, when a person passes a surety mortgage bond, it is not simply them saying, use my property as security. It is them saying, over and above using my property as security, if the loan is not paid back and my property is not enough to satisfy this debt, you can also come after me for payment of any other money that is still to be paid. A mortgage bond can also be transferred to another person. And generally, when one looks at a mortgage bond, the only party in this entire situation who can transfer the mortgage bond is the mortgagee. And remember, the mortgagee is the one that gave out the debt. So in this particular scenario, when we continue, the mortgagee would be the bank. So if the bank wants to raise money for whatever reason, then the bank can decide, oh, I have these 5 mortgage bonds that are registered over 6 or 7 properties. I can sell these mortgage bonds to a different bank to raise money. And when these mortgage bonds are sold, then it is what is called a cession. And when a cession happens, because these mortgage bonds have been registered at the deeds registry, then the cession also has to be registered so that the mortgage bonds can be endorsed or stamped at the deeds registry to indicate that the mortgagee is no longer Bank 123, it is actually Bank XYZ. There are instances where a mortgage bond can be ceded by a mortgagee, not for purposes of sale, but to use them as security. In that particular instance, a part of it or certain rights in the mortgage bond are ceded, but not in full. And the reason why I say this is that if the mortgage bond is ceded in full in the form of a sale, and the loan is paid out or paid back in full for the bond, then the cancellation of the bond will be between the mortgagor and the person who has the cession of the mortgage bond. But if it is used as security and the money is paid back in full, then there are three people involved in the cancellation. It will be the mortgagor, it will be the mortgagee, which is the first bank that got the bond, and it will be the bank that then got ceded parts of the rights in the bond. But I will deal with cancellations of mortgage bonds later on in this video. When a person goes to sign the documents for the registration of a mortgage bond, and these documents are prepared by a conveyancer, there is no other person who can prepare this document for registration, then one should go through the entire document to read it and understand. And when a person goes through this mortgage bond, they will see that there is a portion where it will say this is a first mortgage bond. This is because one piece of property can have multiple or more than one mortgage bond registered over it. This usually happens where a piece of property has a high valuation. If a property is valued at 1 million pula and a person goes to the bank and says, use this property as security, give me 250 pula, then the first bond will be for 250 pula plus an additional sum. This additional sum is made for purposes of where now a person has to be sued to recover the debt. If this person, after a year or so, decides they need more money for whatever reason, they can then approach the same bank to get an additional amount on this property. This additional amount could be, let's say, an additional 500,000. You already have the 250 mortgage bond, which is the first bond. Now you want on top of that 500,000. This person might also approach a different bank and say, I have this property, it's been mortgaged to Bank 123, and I want to have more money given to me and using this property as security. What the second bank can do is they can agree to take over the loan or mortgage from the first bank, and this is not an issue of cession. If that happens, then the first bond is cancelled and a new bond is registered with the new bank. However, this bank can decide, fine, we will pass a second bond without you paying the first bond back. In that situation, then inside this mortgage bond document, you will see that it will say this is a second mortgage bond. The reason it is important for this to come out clearly is because if the person who is supposed to be servicing the loan doesn't do so, whether it is just a simple mortgage bond or a surety mortgage bond, and the property is sold, the people are paid back in the same sequence as they appear in the various bonds. So if the second bondholder is the one that sues and the property is sold, they have to pay the first bondholder first before they take their money. It is therefore possible that you, as the second bondholder, can sell a piece of property and recover nothing because it would all have been taken by the first bondholder. It is also important in situations where a person becomes insolvent and the debts have to be paid, or if a company goes into liquidation. If you watch my video where I talk about different capacities of different people and entities, I deal with all of these things of insolvency and liquidations of company in order for you to understand this dynamic properly. And in payment of these creditors, they are paid in accordance to this rank. So the first bondholder will be paid first, the second bondholder, and so on and so forth. However, if a bondholder cannot recover all the money for the property, let's say it's plot A. Plot A is mortgaged for 10,000 pula, but when it is sold, it is only sold for 7,000 pula. It means the 7,000 pula will go to the mortgagee. The 3,000 pula then would have to be recovered in some other way. And if this is the case, then the mortgagee loses the ranking, because the ranking is based on the mortgage bond. And once the property is sold, then the mortgage bond also falls away and the ranking is gone. Therefore, for the remaining 3,000, they would be an ordinary creditor. A mortgage bond can be cancelled under various circumstances. It can be cancelled where the mortgagor, being the person who has used their own property, pays off the loan, or the loan is paid off if it's a surety mortgage bond, and they therefore ask for the mortgage bond to be cancelled. It can also be cancelled in instances where the mortgagor or the other party, if it's a surety mortgage bond, seeks finance from another entity or party or bank as previously described, and then uses some of that money to clear off the bond with the original bank. In that particular instance, what happens is that the original bank will receive what is usually called a letter of undertaking from the new bank. Once they receive the letter of undertaking, they will instruct an attorney to prepare the consent by this first bank to cancel the mortgage bond. Once the consent to cancellation has been prepared and sent to the first bank, it will be signed, and this first bank will then release a signed copy of that consent to cancellation together with the original title deeds. The title deeds here being the deed for the property or lease and the original mortgage bond that has to be cancelled. The company or person or bank that then is going to pass this new bond will give a copy of the letter of undertaking to the attorneys so that the transaction can be dealt with as one thing. By that I mean you have two transactions in one. You have your cancellation and then you have your registration of the second person's bond, such that when the document or deeds come from the deeds registry, you have the title deed for the property as well as the newly registered mortgage bond for the new bank. This is also the case where you register a second mortgage bond without cancelling the first mortgage bond. And it is possible for all of this to happen between two different law firms. And that's instances where you then hear people say, no, we are linking this transaction with the law firm at 123. So once the attorneys receive the consent to cancellation, they then have to take the documents to the deeds registry for the mortgage bond to be cancelled, even if there's no new mortgage bond that is registered. This is also true where a person sells their property. So if we use Mortgagor as an example, Mortgagor has a piece of property in Gaborone. They then decide, you know what, I have this mortgage bond that I've passed over this property and it's 100,000 pula, but I no longer want this property, or I can no longer afford to service this loan. I want to sell this property. They then have to first get the consent from the financier or bank in order to sell that property. And if the property is sold, then the bank will release the bond, the title deed, and also sign in the consent to cancellation once they receive the letter of undertaking from the bank or the financier of the person buying, or once they receive the cash from the person buying if the person is buying in cash, or a bank guarantee check, or whichever way, as long as it can be shown that the money is there and it will be paid once the transaction passes. So if the purchaser is getting a loan from the bank, it will be this entire process of taking the transaction to the deeds registry, and inside that package you have the cancellation of the first bond, you have inside the transfer of the property, and then registration of the new bond where the new person will be recorded as the owner. So you would have 3 transactions in one. And just like the previous one, it is not necessary for them to be done by the same law firm. It's cleaner, but sometimes due to various issues, they can be done by separate law firms. As an aside, and this is less a legal issue as an interactional issue. When a person approaches the bank in order to get a mortgage loan or home loan, there are various things that they have to look at and be aware of. And sometimes it is a shock when people get to the point where they become aware of certain things. One, the person must know that they will be required to do a valuation by the bank. And by that I mean the bank will say to you, we are going to value this property using our own valuers. It doesn't matter whether or not you have your own valuation, but in many instances, the bank prefers to use its own valuation. So your valuation could be 2 days old, but the bank will say, no, we are going to do our own valuation. Secondly, once the bank does that valuation, you have to pay for it. Or in some instances, the bank will say to you, make sure your bank account has enough money to cover this valuation before we can send out the instruction. Once the instruction has been sent out and the valuation report comes, then the bank will prepare or process your home loan agreement. You have to read your home loan agreement and understand it. One of the fundamental problems that people will face is that inside the loan agreement, there will be a portion where they have to pay certain amounts of money as administration fees for purposes of dealing with this loan with the bank. So when you go to the bank for the first time to ask about getting a home loan or a mortgage bond, because not every property that is to be bought is necessarily a home. It could be commercial. You have to ask about the fees for the valuers. You have to ask about the administration costs, as well as any other ancillary costs that might be associated with getting this loan. And the reason why this is important is because you want to make sure that you have enough money to pay for this valuation and administration costs. Because most of the time, the bank will not process the loan without paying or without receiving payment of the administration cost. And the last thing you want is for you to have paid 6,000 or 7,000 for a valuation, and then you're told that the administration cost is 30,000 and you don't have that 30,000. If you don't have that 30,000, then your loan will not be processed and you can't get back your 6,000 or 7,000 because the work has already been done by the valuers. That being said, I hope you got a lot of useful information from this video on mortgage bonds, because a lot of times clients will come and sign mortgage bond documents without knowing exactly what it is that they're signing for. And you find that in certain instances, a person will come as a holder of a surety bond and they're saying, but these people are coming to sell my house, I didn't even get that money, and things like that. So you need to understand what it is that you are signing up for when you pass a mortgage bond over your piece of property. I hope that you will share this video with others for information purposes. And if you want me in following videos to actually go inside the mortgage bond to say to you, when this term is used, this is what it means. When this term is used, this is what it means. Please let me know, because some of those terms you might not understand them, or they might read as ordinary English, but the meaning in law is different from what ordinary English is assigning to that particular word or phrase. If there's anything that you feel I haven't covered or you want me to clarify, please leave comments down below. Leave comments on my social media on Facebook. Leave comments on my Twitter. And please like, share, and subscribe. Thank you for joining me. I will see you in the next video. And bye.